There are no pauses to your life changes, from family dynamics to finances. Is your estate plan keeping up? Spouses get divorced, loved ones pass away, new babies arrive. From welcoming a new family member to navigating changes in relationships, life's milestones often require adjustments to your estate plan. Your will and trust should always be tailored to your current life situation. While it's not necessary to revise your estate plan with every small change, major life events should trigger a review. It's crucial that your estate plan reflects your current circumstances, not those of your past. Here are some scenarios that typically warrant a review of your estate planning documents. Let's say that you want to change your beneficiaries and have other people or charities inherit your property. If you have a revocable living trust, changes to your beneficiaries can be made by amending the trust's distribution provisions or by doing a complete restatement of your trust. You should also review your life insurance and retirement account beneficiary designations from time to make certain that they reflect your current wishes. Imagine thinking that your forms are up to date, only to discover that your ex is still listed as the sole beneficiary. If you have or anticipate a change in marital status, you need to see your estate planning attorney as soon as possible. You should always make a new will or change your trust after a divorce. The failure to reflect this change in your documents could lead to costly litigation upon your death. If you have a child, make sure to review your documents during your annual update of asset lists. Even if your documents state that your assets will go to your then living issue, the birth or adoption of a child generally warrants an update to your documents. Keep in mind that stepchildren and step-grandchildren who are legally adopted into your family become your heirs under the law when they are adopted. Although your attorney should plan for contingencies and alternate trustee appointments in their drafting, the death of a named beneficiary, successor trustee, or guardian generally warrants an amendment so as to avoid any possible confusion and administrative hassle in the future. Also consider making changes to your documents if one of your named successor trustees is incapacitated or otherwise becomes unavailable to serve. You should also periodically check on the named guardians of your minor children. Children grow, people change, and someone who may have been ideal to care for your child in your absence when they were young may no longer be the best choice to carry them through the next stage of their life. Laws also tend to change over time, which means that some of the provisions in your trust may now be obsolete or even counterproductive. For example, when the estate tax exemption threshold was still relatively low a little over a decade ago, many married couples needed an AB trust to minimize or avoid estate taxes. With these trusts, when the first spouse dies, the trust assets must be split into two trusts. One of the trusts becomes irrevocable, meaning that it can no longer be changed and requires its own separate tax return every year. There are many married couples who had taxable estates in 2008 when the federal estate tax exclusion amount was $2 million per person, who don't need those AB provisions in 2025, where the exclusion is up to $13.9 million per person, $27.9 million for married couples. Even though the exemptions are scheduled to revert to the 2017 amounts at the end of 2025, to about $7 million per person indexed for inflation, depending on the size of your estate, a disclaimer bypass trust or a trust with no tax provisions at all may serve your purposes now. Your heirs may also benefit from lower capital gains taxes if you remove those AB trust provisions. So, unless you have another reason to subject yourself to the AB Trust rigmarole, which you should discuss with your estate planning attorney now, your spouse and heirs may benefit significantly by having those AB provisions removed. You may not think that your moderate estate requires particular attention, but depending on the state you live in, careful planning is crucial for anyone with sufficient funds to trigger probate. Remember that your estate plan also includes provisions for your health care during your incapacity. When you're healthy, it may all just seem like a big hypothetical. But if you or your spouse develops a serious health problem, you may wish to do a thorough review of your advanced health care directives with your attorney and physician to make sure that they clearly reflect your wishes regarding medical treatment during incapacity. Asset schedules provide your successor trustees and executors with an up-to-date list of your assets and their approximate values that will help relieve some of their administrative load when you're gone. These schedules also confirm your intent to transfer your assets into your trust. So if an asset is mistakenly not titled in your trust, it may still be transferred to the trust after your death, possibly avoiding the need for probate proceedings. This is generally done through a California Hegstad petition or a similar court process in another state that confirms intent despite improper titling. When interest rates are low or when cash is needed, many people tend to refinance their homes and rental properties. More often than not, title is taken out of the trust during the refinancing process. Make sure that title is placed back in. The time and cost to prepare a new deed is minimal. If you purchase a new piece of real estate, make sure that you take title as trustees of your trust or have your attorney handle that transfer for you immediately after closing. Changes in assets should be made on Schedules A, B, or C to your trust, or to your schedules of life insurance, retirement accounts, and other non-trust assets. You can do this yourself. If you change banks or open a new bank or brokerage account, make sure the title is taken in the trust. This generally does not require an amendment to your estate planning documents. If you started a new retirement account, make sure that you list beneficiaries with the financial institution that is managing it. You should update your asset lists at least once per year and send copies to your estate planning attorney so that their files are kept up to date. Choosing a date for an annual review of your documents is a great way to make sure that your estate plan always reflects your current wishes. You can do this review on your own. Start by updating your asset schedules. Remember to send a copy to your attorney. Then look through the family section, distributions, and successor trustee provisions of your trust to make sure that they are still relevant. Remember to always take notes on a separate piece of paper marked possible changes or something else indicating that these are changes that you are merely considering. You should never write on your documents, even on copies, as this could later result in a will contest. If you need changes made to your estate plan, contact your attorney. Working with an estate planning lawyer is not a one-time event. It is usually a good idea to meet with your attorney at least once every 5 years to review your documents. This can generally be done in a 1-hour meeting. The estate planning and tax attorneys at Paley & Prame can help you ensure that your affairs will be properly managed when you are no longer able to handle them yourself.